Hi, I'm Damon Murdoch, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar presenting from a script that I've written and approved. Artificial intelligence is no longer just helping businesses operate more efficiently. In many workplaces, AI is now actively managing workers. Software is assigning tasks, tracking productivity, monitoring movement, setting deadlines, and even influencing disciplinary decisions. And as of 2026, Australian workplace laws have started to directly regulate that reality. Today, I want to walk you through the new Digital Work Systems Amendments, what they mean for employers, and why businesses using AI-driven management systems may now face significant workplace health and safety and industrial relations risks. The new laws introduce a broad definition of what is called a digital work system. This is designed to capture the growing use of AI and automated software in modern workplaces. Importantly, this is not limited to gig economy platforms or delivery apps. The laws may apply if your business uses software that automatically assigns work, determines routes, sets deadlines, or allocates tasks. That could include warehouse management systems, field service dispatch software, or even project management tools used in white-collar workplaces. The definition also extends to monitoring tools. For example, software that tracks keystrokes, measures active hours, monitors GPS locations, or collects wearable device data may now fall within this regulatory framework. Moreover, systems that rank employees, calculate bonuses, or trigger disciplinary actions using algorithmic decision-making are also included. One of the major themes behind these reforms is transparency. The black box approach to AI decision-making is no longer acceptable where those systems materially affect workers. At the core of these amendments is workplace health and safety. The law now recognizes that digital management systems can create psychosocial hazards. One example specifically recognized is algorithmic pacing. That's where software sets a work pace or productivity expectation that workers cannot reasonably sustain over long periods. In practical terms, this means employers now have a positive duty to assess whether their digital systems are contributing to fatigue, stress, burnout, or other psychological risks. And this obligation is proactive. Businesses cannot simply wait for complaints or incidents to occur. The amendments also create stronger consultation and transparency obligations. Employees must now be consulted about how digital work systems are implemented and used to monitor performance. Workers also have a right to understand how the algorithm is assessing them and what data is being relied upon when decisions are made about their employment. That is a major shift. Historically, many automated systems operated with very little visibility or explanation. Under the new framework, businesses may need to explain not only what data is collected, but how the system uses that data to produce outcomes. One of the most significant changes is the introduction of what is effectively a right to human oversight. Under the amendments, important employment decisions cannot be left entirely to automated systems. For example, decisions involving termination, demotion, or significant disciplinary action must involve meaningful human oversight. That means a real human manager must have authority to review and override the algorithm's recommendation. In other words, employers cannot simply say, the system made the decision. So what should businesses be doing now? First, businesses need to identify every system that manages or monitors workers and determine whether it falls within the new definitions. Then, employers must make sure that employment agreements and contractor agreements clearly disclose the use of digital work systems. Employers also need to ask practical work health and safety questions. If an algorithm sets delivery routes or productivity quotas, are those targets realistic? Can they be overridden where there are safety concerns such as extreme weather, fatigue, or traffic conditions? And finally, businesses should carefully review whether their systems create psychological risks that now require formal work health and safety assessment and mitigation. These changes also matter for developers of HR and management software. If your platform influences employment decisions or workplace monitoring, your clients may now expect features that support legal compliance, including transparency, human review mechanisms, and safety-based overrides. The legal risk no longer sits only with employers. Software design itself may increasingly come under scrutiny. The rise of AI management systems is fundamentally changing the workplace. The 2026 Digital Work Systems Amendments reflect a growing legal expectation that efficiency cannot come at the expense of worker safety, transparency, or human oversight. Businesses now face the challenge of balancing the benefits of AI-driven systems with increasingly complex legal obligations under workplace health and safety and employment laws. At Leo Lawyers, we advise businesses on AI governance, workplace compliance, and emerging technology regulation. If you'd like tailored legal advice, you'll find our contact details in the description box, or you can visit us directly at leolawyers.com.au. Thank you for watching.